Chapter 15. Conspiracy. 8265. Definition. It has been said that there is, perhaps, no crime, an exact definition of which it is more difficult to give than the offense of conspiracy. It may, however, be defined as a combination between two or more persons to accomplish an illegal purpose, either by legal or illegal means, or a legal purpose by legal means. The purpose or means may be legal either at common law or by statute. Bovia defines conspiracy as a combination of two or more persons by some concerted action to accomplish some criminal or unlawful purpose, or to accomplish some purpose, not in itself criminal or unlawful, by criminal or unlawful means. Bishop states that conspiracy is the corrupt agreeing together of two or more persons to do, by concerted action, something unlawful either as a means or an end. Desti observes, a criminal conspiracy is 1. A corrupt combination. 2. Of two or more persons. 3. By concerted action, to commit. 4. A criminal or an unlawful act. A. Or an act not in itself criminal or unlawful, by criminal or unlawful means. B. Or an act which would tend to prejudice the public in general, to subvert justice, disturb the peace, injure public trade, affect public health, or violate public policy. 5. Or any act, however innocent, by means neither criminal nor unlawful, where the tendency of the object sought would be to wrongfully coerce or oppress either the public or an individual. Chief Justice Shaw defines it as a combination of two or more persons, by some concerted action, to accomplish some criminal or unlawful purpose, or to accomplish some purpose not in itself criminal or unlawful by criminal or unlawful means. And as stated by Justice Gilchrist, the authorities agree in stating that a conspiracy is a confederacy to do an unlawful act, or a lawful act by unlawful means, whether to the prejudice of an individual or of the public, and that it is not necessary that its object should be the commission of a crime. Judge Fitzgerald pertinently observes, conspiracy is aptly described as divisible under three heads, where the end to be attained is itself a crime, where the object is lawful but the means to be resorted to are unlawful, and where the object is to do injury to a third person or to a class. Though if the wrong were effected by a single individual it would be a wrong, but not a crime. The trend of recent decisions is to hold, in many instances, that a combination to do an act, which would be lawful if done by an individual is indictable. It is not necessary either that the purpose should be criminal or the unlawful means criminal. Section 266. Gist of the offense. The gist of the crime of conspiracy is the unlawful combination. As a general rule, no attempt to carry out the agreement is essential. The agreement itself constitutes a sufficient overt act. In some states, however, by statute, a distinct overt act is essential in certain specified cases. Section 267. Contemplated crime, one of which concert of conspirators is a constituent part. When the contemplated crime is one of which concert of the conspirators is a constituent part, such as adultery, fornication, incest and bigamy, the courts hold that the mere agreement to commit it is not an indictable offense. The conspiracy in such a case is not treated as an integral offense, but rather as an integral part of another offense. But it has been held a woman may conspire to commit an offense against the United States, although the object of the conspiracy is her own transportation in interstate commerce for purposes of prostitution, in violation of the White Slave Act. 8268. Third party implicated. When a conspiracy to commit adultery, fornication and the like, implicates a third party, the conspiracy itself is indictable. It was said in one case, the appellant contends there is no such crime as conspiracy to commit adultery. This case is readily distinguishable from Shannon v. Commonwealth, and Miles v. State. In those decisions the agreement of a married woman to have intercourse with a man other than her husband was held not to amount to a conspiracy to commit adultery, for that the consent involved was a part of the offense itself. One may aid and abet in adultery without actually participating in the act. And we can discover no ground for saying that a combination to commit the unlawful act, not an agreement between the immediate parties to the intended crime, may not constitute a conspiracy. The same principle is involved where the conspiracy is maliciously to injure another in his business, and it is essential that both conspirators combine to effect the purpose contemplated. $269. When the unlawful agreement is of itself a crime. The doctrine that where concert of action is essential to a crime a charge of criminal conspiracy does not apply when the unlawful agreement is of itself a crime, but applies only when the agreement and the consummation thereof are so closely connected that the two constitute really but one offense, as in the case of fornication, adultery, bigamy and the like. The doctrine is invoked that where concert of action is necessary to the offense, conspiracy does not lie. That principle is familiar, but its application, as its language clearly indicates, is necessarily confined within very narrow limits. It does not reach a situation where mere combination to effect an object is itself criminal and not merged in a crime of higher degree, else the absurd result would follow that the offense of conspiracy would be impossible either at common law or under the statute. The rule applies where the immediate effect of the consummation of the act in view, which is the gist of the offense, reaches only the participants therein, and is in such close connection with the major wrong as to be inseparable from it, as for instance, in the offense of adultery, or bigamy, or incest, or dueling. $270. Wharton's view. When to the idea of an offense plurality of agents is logically necessary, conspiracy, which assumes the voluntary accession of a person to a crime of such a character that it is aggravated by a plurality of agents, cannot be maintained. As crimes to which concert is necessary, i.e., which cannot take place without concert, we may mention dueling, bigamy, incest and adultery, to the last of which the limitation here expressed has been specifically applied by authoritative American courts. We have here the well-known distinction between concursus necessarius and concursus facultativus, in the latter of which the accession of a second agent the offense is an element added to its conception, in the former of which the participation of two agents is essential to its conception, and from this it follows that conspiracy, the gist of which is combination, added to crime, does not lie for concursus necessarius. Section 271. Mode of making the agreement. It is not essential that the agreement be a formal one. Concurrence of sentiment, and cooperative conduct in an unlawful and criminal enterprise, and not formality of speech, are the essential ingredients of criminal conspiracy. It is sufficient if two or more persons, in any manner or through any contrivance, positively or tacitly come to a mutual understanding to accomplish a common and unlawful design. Section 272. Nature of the purpose involved. An agreement to perpetrate an unlawful act is indictable at common law. Just what is sufficient to constitute such an act, however, is difficult to determine. To attempt to define the limit or extent of the law of conspiracy as deducible from the English decisions, would be a difficult if not an impracticable task. We may safely assume that it is indictable to conspire to do an unlawful act by any means, and also that it is indictable to conspire to do any act by unlawful means. In a leading Maryland case, in which the early English cases upon the subject are exhaustively reviewed, Justice Buchanan enumerates the following classes of cases in which an indictment will lie. For a conspiracy. 1. To do an act criminal per se. 2. To do an act not illegal, nor punishable if done by an individual, but immoral only. 3. To do an act neither illegal nor immoral in an individual, but to effect a purpose which has a tendency to prejudice the public. 4. To extort money from another, or to injure his reputation by means not indictable if practiced by an individual. 5. To cheat or defraud a third person, accomplished by means of an act which would not in law amount to an indictable cheat, if effected by an individual. 6. To impoverish or ruin a third person in his trade or profession. 7. To defraud a third person by means of an act not per se unlawful, and although no person be thereby injured. 8. To cheat or defraud a third person, though the means of effecting it should not be determined on at the time. Section 273. Historical development of the term. At the ancient common law, the term conspiracy had a much narrower meaning than it has today. In very early times, the word had a completely different meaning from that which we attach to it. Section 274. Conspiracy to commit a crime. A conspiracy to commit any act that is a crime is indictable at common law. This is so self-evident that it can scarcely be necessary to offer any authority. Moreover, whether the act be a felony or a misdemeanor, or a crime at common law or by statute, is immaterial. Section 275. Conspiracy to commit an immoral act. A conspiracy to accomplish an immoral act is also indictable at common law. It is not essential that the object of the conspiracy be indictable. Thus, a conspiracy fraudulently to procure a girl to have sexual intercourse with a man is indictable although the object of the conspiracy is not. In determining what sort of conspiracies may be entered into without committing an offense punishable by the common law, regard must be had to the influence which the act, if done, would actually have upon society. So a conspiracy to procure a sham marriage is indictable, and a conspiracy to procure a husband to desert his wife, and also a conspiracy to commit adultery, which implicates a third party, otherwise not. Section 276. Conspiracy to commit a mere civil wrong. In general, it has been held repeatedly that a conspiracy to accomplish an object which constitutes a mere civil wrong is not indictable. On the other hand, Hawkins observes, there can be no doubt but that all confederacies whatsoever, wrongfully to prejudice a third person, are highly criminal at common law. Chitty says, all confederacies wrongfully to prejudice another, are misdemeanors at common law, whether the intention is to injure his property, his person, or his character. This view is in accord with the great weight of authority. Section 277. Conspiracy to commit a civil trespass. It also has been held that a conspiracy to commit a civil trespass is not indictable. One textbook writer has said a conspiracy to commit a mere trespass on real estate is not criminal, because such an act by one person is not, for in this instance, differing from the last, conspiracy to cheat, combined numbers have no more power for harm, and do no more harm, than if each proceeded with his part of the mischief alone. The foregoing view, however, is not in accord with the weight of authority. Section 278. Conspiracy to perpetrate a fraud. A conspiracy to perpetrate a fraud upon another is indictable at common law, and whether the party to be defrauded be a natural or an artificial person is immaterial. According to the great weight of authority, a conspiracy to defraud individuals or a corporation of their property, may constitute an indictable offence without regard to whether the act done or proposed to be done by the conspirators in pursuance of the conspiracy, be indictable or not. Thus, a conspiracy to charge another falsely with being the father of a bastard child, a conspiracy to cheat another at cards after getting him drunk, a conspiracy to marry paupers in order to charge one parish and exonerate another, a conspiracy to induce another, by making false representations to him, to abandon a legal claim, a conspiracy fraudulently to induce an illiterate person to sign a certain instrument by falsely representing to him that it is something different, a conspiracy fraudulently to acquire from a county a certain sum of money, a conspiracy to get possession of land by means of an extorted deed in favor of the lawful owner, a conspiracy to obtain another's goods or money by false pretenses, a conspiracy to stifle competition at an auction sale, a conspiracy between a female servant and a man to perpetrate a fraud upon her master's relatives by the man personating her master and marrying her as such, with the view of defrauding the master's relatives out of part of his property, a conspiracy to defraud another by inducing him to bet on a horse race which the conspirators know is to be fraudulently run, a conspiracy to obtain money from a streetcar company by fraudulently representing that a certain person was a passenger on a car and injured by its derailment, and a conspiracy to attempt to deceive the general public by conducting materializing seances, and masquerading as spirits of the dead have all been held indictable offences. Section 279. Conspiracy to slander or extort money from another. A conspiracy to injure another's reputation by slandering him is, as a general rule, at least, an indictable offence. Some authorities, however, hold that there are exceptions to this rule, and that the mere conspiracy to slander a man will not be sufficient, but there must be, combined with it, the imputation of a crime cognizable either by the temporal or ecclesiastical courts, or else an intent, by means of such false charges, to extort money from the party. All the authorities agree that a conspiracy falsely to charge another with the commission of a crime is an indictable offence. Moreover, in an indictment for a conspiracy to accuse another of a crime it is not essential to allege that the defendants procured, or intended to procure, an indictment or other legal process. It is also well settled that a conspiracy to extort money from another is indictable. Thus, as heretofore stated, a conspiracy falsely to charge another with the paternity of a bastard child is a crime. Section 280. Conspiracy to obstruct or pervert public justice. Since a willful obstruction or perversion of public justice is indictable, a conspiracy to accomplish it is also indictable. Thus, it is an indictable offence to conspire to cause a marriage falsely to appear of record, and to obtain for that purpose from a justice of the peace a false certificate thereof, and from other parties false statements that they were witnesses of the ceremony, with intent to prevent a person from contracting another marriage, or to conspire to induce a witness to suppress evidence, or give false evidence, or to conspire to pack a jury, or to conspire to commit an assault and battery upon a peace officer with the view of preventing him from making a legal arrest. Section 281. Labor combinations. Labor unions are combinations of workmen whose object is the improvement of their industrial conditions. The formation of labor unions for the purpose of mutual protection against unfairness or oppression is not unlawful unless it contemplates accomplishing the object sought by unlawful means. Moreover, both in England and in this country workmen are encouraged to form associations for their mutual benefit. The real status of labor unions and strikes has been the subject of much discussion, both by political economists and by lawyers and jurists, and one upon which eminent jurists have rendered discordant opinions. In a leading English case upon the subject, certain journeyman tailors were indicted for conspiring to raise their wages. The proof showed that they had entered into a compact to refuse to work unless their wages were increased to a certain amount. It also showed, however, that the sum demanded was in excess of that allowable under a general act of Parliament, and they were convicted on the ground that the object of the combination was unlawful. Section 282. English statutes. Statutes have been enacted in England which make it a crime to molest and obstruct a workman with the view of coercing him to quit his employment. They also make it a crime to molest and obstruct an employer with the view of coercing him to change his mode of carrying on business. The Statute of 22 Vict. enacts, among other things, that no workman or other person, by reason merely of his entering into an agreement with any workman, or by reason merely of his endeavouring, peaceably and in a reasonable manner, and without threat or intimidation, direct or indirect, to persuade others to cease or abstain from work, shall be guilty of molestation or obstruction, within the meaning of the said Act of 6 Geo. 4. The Conspiracy and Protection of Property Act of 1875 enacts that a combination of two or more persons to do or procure to be done any act in contemplation or furtherance of a trade dispute between employers and workmen shall not constitute an indictable conspiracy unless such act committed by one person shall constitute a crime. Section 283. Combinations to force other employees to quit work. Strikers may combine to persuade other workmen to leave the service of their employer. Their endeavours, however, must be peaceable and reasonable. If, however, the purpose of the combination is to control the free agency, or overcome the free will, of the fellow workman by force or intimidation, the combination is a crime. Actual violence, however, is not essential. Thus, where employees of a railroad company that is in the hands of a receiver are dissatisfied with the wages paid them, they may abandon the employment, and by persuasion or argument induce other employees to do the same. But if they resort to threats or violence to induce the others to leave, or accomplish their purpose, without actual violence, by overawing the others by preconcerted demonstrations of force, and thus prevent the receiver from operating the road, they may be punished for their unlawful acts. It has been held that where employees agree to quit work simultaneously, in large numbers and by preconcerted action, unless their employer discharge certain of their fellow workmen, the agreement constitutes an indictable offence. On the other hand, it has been recently held that, under the modern rule, it is not unlawful for workmen, with the view of increasing their wages, to agree to quit work simultaneously and by preconcerted action. It is well settled that workmen may form themselves into a society and agree not to work for any person who shall employ a non-union workman, after notice given him to discharge such person. Section 284. Boycotting. Definition, origin of term. The meaning of the term boycotting is somewhat vague. The word is not easily defined. It is frequently spoken of as passive merely, a let-alone policy, a withdrawal of all business relations, intercourse and fellowship. It may be defined, however, as a combination of persons whose purpose is to injure another party by preventing other persons from doing business with him through fear of incurring the displeasure, persecution and vengeance of the conspirators. The term had its origin in Ireland during the premiership of William Ewart Gladstone. Captain Boycott, an Englishman, and agent of Lord Erne, who was owner of an estate in Ireland, was ostracised by his neighbours. The population of the region for miles round resolved not to have anything to do with him, and as far as they could prevent it, not to allow anyone else to have anything to do with him. His life appeared to be in danger. He had to claim police protection. His servants fled from him as servants flee from their masters in some plague-stricken city. It is to be observed, therefore, that the term originally signified violence. In many instances boycotts in our own country have been attended by violence, and indeed it is a natural tendency when a boycott is instituted by ignorant or vicious persons to attempt by force to make it successful. Section 285. Legality of act depends upon means employed. It is often said that, what one man may lawfully do singly, two or more may lawfully agree to do jointly. The number who unite to do the act cannot change its character from lawful to unlawful. A workman may refuse to trade with any party he chooses, absolutely or conditionally. It follows, therefore, that many may do likewise, and an agreement by them so to do is not unlawful. Whether a combination to boycott a third party is lawful or not depends upon the means to be employed to carry it into effect. Peaceable persuasion in deterring others from dealing with that party and the withdrawal of their own patronage from him are lawful acts. On the other hand, if violence is contemplated, the combination is unlawful. When the act contemplated has a necessary tendency to prejudice the public or oppress individuals by unjustly subjecting them to the power of the confederates and giving effect to the purpose of the latter, whether of extortion or mischief, the combination is unlawful. Thus, a combination by members of a typographical union to compel a firm of printers to make their office a union office, and upon the refusal of the firm so to do, to boycott the firm, and send circulars to many of its customers notifying them that such firm is boycotted, and that the names of all persons who continue to patronize the firm will be published in a blacklist, and that such persons will be boycotted until they agree not to patronize such firm, is an unlawful combination. And a combination of union workmen whose purpose is to intimidate and drive non-union workmen away from their employment by threatening that unless they quit the service of their employer their names will be published in the scab list in the Journal of the Union Workman, and that they will be shunned and not allowed to work with union workmen engaged in a like occupation, is an unlawful combination. Section 286. Picketing, injunction. Picketing consists in detailing men by a labor union to watch an employer's place of business and speak to his workmen as they come and go with the view of inducing them to leave his service. It is not unlawful per se, but when carried to such an extent as to amount to violence or intimidation it is unlawful. In some cases a court of equity will grant an injunction to prevent workmen from doing unlawful acts. Thus, a court of equity will restrain by injunction discharged employees, members of a union, from gathering about their former employer's place of business, from following the workmen whom he has employed in their places, and from interfering with them by threats, menaces, intimidation, opprobrious epithets, ridicule and annoyance on account of their working for the complainant. It also will restrain by injunction the maintenance of banners displayed in front of a person's premises with inscriptions calculated to injure his business and to deter workmen from entering into or continuing in his employment. When, however, the party injured has an adequate remedy at law an injunction will be denied. Thus, in a complaint for an injunction to restrain a boycott on one's business, allegations that the officers and members of a certain trades union conspire to compel the plaintiff to submit to the dictation of the union upon pain of being boycotted in business, that the executive committee of the union entered his place of business without leave or license and ordered the union men at work therein to cease work under penalty of being dealt with according to the laws and regulations of the union, that the defendants induced the city council, by threats of boycott at the polls, to reject the plaintiff's bid for the city printing, although it was the lowest made, that defendants threatened to boycott the plaintiff's customers if they patronized him, whereby he lost one customer and would lose another, and that defendants circulated a knowledge of such acts by the posting of notices, all of which acts were committed within a space of about 10 months, to the past and future injury of the plaintiff's business, do not justify an injunction, as such acts do not show that the plaintiff is without an adequate remedy at law, or that the injury will be irreparable unless enjoined. Nor will an injunction be granted to restrain strikers from leaving the service of their employer. This is owing to the fact that a mandatory injunction will not be allowed in any case to compel the performance of personal service. Moreover, to grant an injunction in such a case would place the parties enjoined in a condition of involuntary servitude, and, therefore, would be a violation of the United States Constitution. The fact that a threatened irreparable injury if committed would constitute a crime, is no bar to an injunction against the threatened injury. It has been held, however, that equity will not enjoin the publication of a libel. Section 287. Combination to raise prices. Lord Ellenborough has pertinently observed that every corner, in the language of the day, whether it be to affect the price of articles of commerce, such as breadstuffs, or the price of vendible stocks, when accomplished by confederation to raise or depress the price and operate on the markets, is a conspiracy, and that to combine to raise the price of the public funds on a particular day is an indictable offence. It also has been held that an agreement by several coal corporations to divide the market for coal, from the two coal regions of which they had control, in certain proportions, to appoint a committee to take charge of the business of all the corporations and to appoint a general sales agent, to deliver coal at such times and to such parties as the committee should, from time to time, direct, that the committee should adjust the prices of coal in the different markets, that the general agent should direct a suspension of shipment or delivery of coal by any of the companies making sales or deliveries beyond its proportion, is against public policy and illegal, and by statute an indictable offence. It is to be observed, however, that an agreement in unreasonable restraint of trade is not necessarily an indictable offence at common law. It has been said in a carefully considered opinion, contracts that were in unreasonable restraint of trade at common law were not unlawful in the sense of being criminal, or giving rise to a civil action for damages in favour of one prejudicially affected thereby, but were simply void, and not enforced by the courts. It has been held that a combination of insurance companies to fix insurance rates is not indictable, either at common law or by statute. In Kansas, however, such a combination has been held a misdemeanor by virtue of a statute,